Great. How are you doing?
I'm good, thank you. How are you?
Doing well. Doing well. What's new in the world
In the
over
world?
there?
Well,
World of tax.
regarding the employee retention credit, what's happened is on September 14th, 2023, the IRS issued a moratorium for processing returns filed after that date, saying they weren't going to process the returns after that date, but the returns that were filed previous to that date, they would still continue processing. And they said it's going to go from a 90-day window to a 180-day window. They said the moratorium is going to last until at least the end of the year. Well, since then, obviously, it's July of 2024. So since then, there's been a couple of updates. The commissioner has said that he hopes the moratorium is going to be lifted by late spring. And then we get even further. And on June 20th at like 4 o'clock, right before the summer solstice, the commissioner announced an information release that the moratorium is going to continue. And not only that, but that in the amount of time since the moratorium has been enacted, so since September 14th, 2023, only 28,000 returns have been processed, where there are 881,000 returns in that queue of pre-moratorium filings. So originally they said that these returns were going to continue to get processed, but the discussion is that there's so much fraud in the system that the IRS is having trouble distinguishing good claims from bad claims. And so in this most recent update, the IRS has talked about kind of like three different tranches. 10 to 20% of claims they feel are low risk, most likely eligible, that they're going to continue to process. 60 to 70% of claims where they think that there's more information needed. And then another 10 to 20% where they feel the claims should be just disallowed. And that's all clearly on like a civil side. So while they're ramping up these civil investigations and audits and things like that, I think there's also some updates as far as like what's going on, for really bad preparers in the criminal space. I don't know if you have an update on that.
Yeah, absolutely. You know, there's compare, and when I look at these with the ERC tax credit fraud and the cases they're bringing, I think the closest comparable thing we have is kind of like the PPP fraud or the idle loan fraud, and the numbers that we're seeing with the ERC tax, it just seems like, and I believe there's been about 36 indictments that have been
Mhm.
brought, right around 450 cases, and there's going to be tons more, right? They're going to be coming, and we're seeing them already. We're seeing them in South Florida. A lot of the kind of really high profile ones so far, some of the bigger numbers have been more in the Northeast, and two really big ones out of New Jersey. But I think what really stands out with the ERC, and I'd like to also, I want to hear your thoughts on this and why, kind of from that tax expert perspective, is the amount of money that these alleged perpetrators, right, are potential clients, but alleged abusers of the system are requesting is very bold. We see in so many of these PPP cases that whether it's like the promoter, right? Because with the ERC tax credits, we see that the promoters, just like they were in PPP, but to a even higher level,
Absolutely.
right? As far as the brazenness of the lack of subtlety in the advertisements that tax preparers or newly minted tax preparers, or maybe they're not really tax preparers so much at all, we're doing. What we'll see in PPP, there's that certainly cases where people are requesting, talking about fraudulent numbers in the millions, but low millions. I don't think I've seen many PPPs where anyone was really requesting more than 10 or so million. That's kind of would be considered high. Usually it's more 500,000 to a million range or lower. But we're seeing in these cases, especially these two in New Jersey, one being from 2023 and now a more recent indictment brought a couple of months ago in 2024. I mean, one of them is 124 million was requested from the IRS, and in this most recent indictment that I was reviewing, it was 2.9 billion that was requested. And so, what do you think it is about this credit, about this program that was offered that allows for just these bold and brazen requests, right? Like, I'm just going to go to the IRS and not even be subtle. We're going to ask for 2.9 billion in refunds. Like, that's, you don't see that every day. I mean, even in the more high end white collar or very complex cases with high numbers, it's kind of really up there.
Yeah, absolutely. I think part of the problem here is that unlike PPP, where you had to submit a loan application and have documentation behind it. So if you were going to perpetuate fraud in that way, you would need to show all of these records. You'd be making these false statements, false documents to go with your application. The employee retention credit is a 941X. And so there isn't any corroborating documentation that is asked for at the time of the submission of the return for the IRS to review, to make a determination of whether or not it's fraudulent, whether or not this business existed, whether there were employees. They're working on their system and they're trying to do matching programs where they say, okay, this company didn't exist prior to the pandemic. We should look at this one more closely. Or this company had 5 employees in 2019. Why would we think it has 400 employees in 2021? That's a big ramp up. That should give us a sign for pause. But in general, there just isn't that much information that's submitted with the employee retention credit. And at first, these were being processed without question. The returns were just submitted, processed, and paid. Some were audited, but it was a really low number. And that's when the IRS kind of like drew a line in the sand, put a stopping to processing older claims because the amount of claims they were receiving had tripled, quadrupled in the amount of time since, a year prior.
Right.
So had there been more to that 941X, had there been more information that's required that shows why you think you're eligible, what government orders did you have, show payroll records, things like that, more documentation, I think that would have helped some of it. Some of the egregious players, I think, still would have probably tried to go for it anyway.
Has the IRS, have they commented on why they were so lax? I mean, even with PPP, I mean, we're talking about hundreds of billions of dollars, right? And so people are going to find a way if they want to try and cheat the system. But have they said why they didn't require more? Have they taken any responsibility on their end?
The responsibility that they're taking is the stopping of the returns processing. They have been talking to Congress and trying to get legislation changed to have much bigger promoter fraud penalties, civil fraud penalties, to extend the statute of limitations on audit. So right now, tax year 2020 is outside the assessment statute. 2021, the assessment statute expires April 15th of 2025 for Q1 and Q2, and April 15th of 2027 for Q3. There's proposed legislation that's actually passed the House and is being stalled in the Senate because it's an election year, and they're not passing tax policy right now. But there's been this legislation that talks about a 6-year audit statute from the date of processing. So some folks have filed returns 2 years ago, hasn't been processed yet. So say it processes in a year, that would be almost a 9-year statute to audit these claims and gives the IRS an ability to kind of come back and claw back some of this money. But that's why I believe that the IRS just has not processed very many claims at all. Like 28,000 out of 881,000 in almost a year is about 700 a week. Some folks who are better at math than me said that it would take them 83 years to process it all, just the pre-moratorium claims. And so it puts the IRS in this very tough spot because Congress enacted this legislation without a ton of structure behind it and no financial resources behind it, asking the IRS to process it. Whereas at least with PPP, it went through the banks and banks were able to kind of build up these processes, and they had to review the application first and they reviewed the forgiveness applications as well. So it was like a 2-part process, right? The application and the forgiveness, and whether or not those loans were totally taken off the books. Whereas here, you're just filing a tax return with some numbers on it. If they process, then, you know, these bad actors really are able to get away with it, which is why they've kind of stopped.
Okay. So and there was also some, I guess, some safeguards for the filer in place, which is done now. And they did have a voluntary disclosure program. My understanding is that it was terminated in March. Is that correct?
That is correct. So there was about 2,300 applications that were submitted through the voluntary disclosure program. And the Treasury was able to receive a lot of money through that program. It was a taxpayer-friendly split where taxpayers were able to keep 20% of the refunds and interest and not make a claim against their income tax return, not amend their income tax return to pick up that income, and gave the IRS 80% back. There is discussion of a new voluntary disclosure program that we think will be launched in the next week or two, where either it's not going to be as beneficial as the first one. We think they're going to keep either 85% or 90% and leave the taxpayer with less.
So, you know, on the with PPP, when clients would come to us, they either felt they might have criminal exposure or just really wanted to consult with us on whether things were done correctly. One of the main questions that we get is, should I pay it back? Right. And that's, as a criminal defense attorney and from a criminal intent standpoint, that's always a really hard question. It's case by case, and you pay it back. Is that an acknowledgement of, it doesn't relieve you from any criminal wrongdoing? There was no, that I'm aware of, real self-disclosure program. I mean, there was things in place that you could contact the SBA if you believed that you had received the funds inappropriately. But in certain cases, if a client would come to me and I would do an assessment and says, yeah, it does seem that you might have exposure here. There may have been some fraud either in the way you applied for this or in the way you spent the money. You might not want to pay it back. Right? And that's very much dependent on whether law enforcement had contacted them or not, because you could pay it back and you could still get charged. And then at the same time, you've paid it back. You have acknowledged wrongdoing, and there were cases that were still brought. Right, there wasn't that safeguard. But I guess in the civil world, I mean, do you get those kind of questions? Have you dealt with any clients who have believed that they have received this credit wrongfully, whether on accident or on purpose? Like, how is it? What are you kind of seeing in your practice on the civil side?
So it's interesting. So first, this voluntary disclosure program, typically voluntary disclosure programs do have protections against criminal exposure. This one did not, and very specifically laid out that this does not give you a blessing from possible criminal charges. We would still recommend filing in most cases. The people we spoke with, we recommended filing for the voluntary disclosure. Right now, because we think there's going to be another program, we have talked to clients about, do you want to pay it now? Do you want to wait and see? How would you like to handle this? It's obviously up to them. Give them as much information as we can so that they can make the best decision for them going forward. What we are tending to see is the opposite. We're seeing people who believe they're entitled to the credit, and we will do a second review and we'll have to have a harder conversation about, well, we think you were eligible for these quarters, but maybe not these quarters. So our recommendation would be either to withdraw those claims, because there's a withdrawal program as well, where you can take your returns out of the queue of that $881,000, or file a return and pay it back one way or another.
And the withdrawal, that's still in effect, is my understanding? Yeah. Or okay.
It is. And not only that, you can withdraw once you're under exam. So an auditor can contact you about a case and you can say, actually, I'm going to withdraw my claim, which is very unique to this program specifically. Usually, once you are being investigated or examined by the IRS, you are not able to just withdraw claims going forward.
So what is from what you've seen, do you have people who are coming? I'm assuming that you do, but maybe not. You have people that are coming to you once they've already gotten notice of the audit, or are you doing more proactive kind of on the compliance side, or a mix?
So there have not been as many audits as we expected, given the amount of claims that are out there. We expected the IRS to really be ramping up their audit and compliance. My understanding is that's going to happen probably toward the later part of the summer, early part of the fall. What we're seeing is people who are frustrated because they haven't gotten their refunds and they want us to evaluate their claim for a refund litigation suit or something along those lines. And when we do our analysis, we make a determination that actually, like, maybe you aren't eligible for as much as you think you are. Maybe you did go to a promoter. Maybe you went to somebody who maybe doesn't understand the credit in the same way that we do. And so then we have to give you advice as far as like whether or not we think you should kind of continue down this path. And those are hard choices because people have believed they are entitled to the money and they've now spent money trying to get the money. And, you know, in their mind, it's already spent. Like they already know what they're going to use it for, to pay this bill or to pay the rent or to expand, whatever it is. And to explain that, like, actually, that's really not the case, is a challenge. Right. And then some of these promoters are saying, even though you're withdrawing your claims, we think that we should still get the fee on the total amount because that's what we filed for, which we clearly disagree with.
Right. So that's a good point. The fee, and I mean, what we're seeing, that's and from the criminal perspective, that's always a maybe one of the first red flags, and the most DOJ's favorite kind of circumstantial evidence is you say everything else that you either didn't really know or you didn't read enough. Certainly, you know, most people would be surprised if they were having to give 15, 20% or more of their tax refund to the preparers. So what are you encountering regarding the fees? Are there, you know, ranges? Is there specific numbers that you've seen that are kind of like I guess the trigger point? Like if it's 10%, you know, major red flag. If it was 5%, normal. Is there any kind of spectrum as far as like what you're seeing in these cases as far as the fee that the tax preparers are requesting?
So our perspective is that any type of contingency fee arrangement to file a tax return to receive a refund is improper.
Across the board, or not just for ERC, right?
Right, across the board, because it incentivizes your preparer to increase your refund. And that is through Circular 230. It's just not something that if somebody who's practicing before the IRS or a licensed tax preparer should be doing for refund claims. So in general, we would say a contingency fee type model for a refund claim is not proper. I know there are very legitimate players in the space that have charged contingency fees or have charged, you know, a deferral on the fee. And I think I can understand it in that somebody's coming to you in desperate times because their business was impacted by COVID. They lost all this revenue. They can't pay anything. They believe, you know, you're entitled to $1 million, but they don't have the money to have you prepare the claims. They say, okay, let me pay you when I get paid. That I can understand. I can empathize with the taxpayer and I can empathize with that preparer. As far as having a contingency agreement where the refund amount and the interest amount actually, if it goes up, it is better for the preparer, is problematic.
Right.
I actually had a client where their 2020 claim originally was like, the refund was for like $1,000. And so he was like, I don't want to do that. And the preparer kept finding more and more credit. As everything continued, there was no more information given, there were no more documents submitted, but somehow they still continued to find additional credit in that tax year. And again, you know, there is some sort of incentive for these preparers if it's tied to the percentage of the refund.
Okay. Yeah, understood. And they're not you know, when they're submitting these forms, right, and they're very, very minimal checks, if any, and balances before they're dishing this money out. The IRS, are they checking to see if these businesses are even legitimate? I mean, are they doing any sort of
So
search?
at
Because
this
then I'm
point,
looking
yeah, absolutely. So in the
now,
beginning, there
now,
wasn't
right?
any. Yeah. So now they're doing a lot of checks. And what they're doing, my understanding is they're also feeding like a computer with governmental orders and NIC codes and like overlapping with Social Security information, other types of government resources to make determinations on how strong this claim is and whether or not more information should be needed. Now, again, it's tough because on that 941X, there's still no box to check that says gross receipts or something like that, which would give them a much better understanding what the basis of the claim is. Like, you don't need to look at government orders if the basis is gross receipts. You can just ask for profit and loss statements or bank statements, something along those lines.
Right.
But yeah, now I believe that almost every claim is being looked at before it's being released.
Okay. What is the average or the common client that comes to you, that comes to Rebecca, that is regarding just ERC in
Sure.
general right now in your practice?
Sure. So we have kind of a mix. We have people who are being audited, or their own, financial auditors are saying, okay, well, we can't release these funds until we get a tax opinion or a second opinion from a tax attorney. So we'll handle those types of claims, whether it's an audit through the IRS or reviewing a claim and drafting a tax opinion and explaining our level of confidence on what we think it's an eligible employer, whether the credit was calculated properly. So that's kind of one tranche. Another tranche is, folks who just haven't been paid yet, and they filed, 2 years ago, and just haven't received their funds yet. So then we can work through whether or not it's a good case for a refund suit, or if it's a smaller claim, say it's $37,000 refund, and which wouldn't be a good, federal district court case, but it is something where we could try to, still advocate on their behalf. And so we might review those claims and try to file something through the taxpayer advocate. If there's a financial hardship, we feel comfortable in the eligibility of the taxpayer. But those folks, it's really hard because the IRS isn't wrong. There is a lot of fraud. There is a lot of problematic, players, like billions of dollars. It's very bad. But at the same time, interspersed with all of that are these legitimate businesses who are eligible for the credit who haven't received their refunds. So it's a very fine line for the IRS to walk in order to determine what's a good claim, what's a bad claim, how do we pay it. We want to make sure we don't let money go out the door we won't be able to recapture, but they're also paying interest on this money. For pass-through entities like LLCs, partnerships, the interest right now is 8%. And so it's a cumulative of like 20% if you go back to the date of origination of the interest. So, it really is adding up from folks who filed and are just waiting for their refunds.
Okay. For some people, you're trying to expedite,
It's possible. Yeah, if
yeah.
there's something that we can do, if there's a way. One of our clients had to file for bankruptcy protection because they took out debt thinking they would be able to service it, thinking the refunds were going to get paid. It's a gross receipt claim, just significant decline in gross receipts. They weren't able to get their refunds in time, and so they had to file for bankruptcy. And then in part of that, we had to file a refund suit in order to get their refunds to pay off the debt. And it's a lot of administrative expense for this company. Whereas if it had just been paid, within 90 days or 180 days, they wouldn't be in that position.
Okay. Gotcha. Is there any kind of, are you anticipating like any potential avenues for like whistleblower actions here when it comes to compliance? I mean, or groups of people maybe that were tied together to one promoter. Do you see any potential avenue for that, as far as maybe someone on the private sector working, who has a lot of clients who have been aggrieved, trying to bring cases to the Department of Justice? Has that been discussed at all in this area, or not so much?
I haven't seen anything about a whistleblower claim, but I think the voluntary disclosure program was somewhat a whistleblower program because you had to blow the whistle
Right.
on your promoter, on your preparer. You had to write who it was, and part of your participation in the program is you working with the IRS and asking, answering any questions that they have regarding your preparer.
I guess that 20% is right, it's 20% that
That's a key. Yeah,
80 to the so that's kind of
their
their
carrot. Yeah, their
settlement.
pay. Mhm.
Okay. So if a client comes into my office
Right.
and says, "Look, I have an ERC credit. I've been watching videos on YouTube. I've been listening to podcasts, and I feel like something might be wrong here, and I'm scared. I'm worried about the government coming after me. What what would you advise criminal defense attorney? Like, what are the main questions to ask? Like the basic kind of core elements to hit with the potential client regard to determine. Obviously, you have to do a deep dive always, but like the major red flags that you're seeing most commonly.
The major red flags are, frankly, Q3 2021 claims. Those are really challenging unless you have a significant decline in gross receipts. Most of the country by July, August, September of 2021 was pretty much open for business. And so if you filed for all 6 quarters, we'd have to understand why. That type of
Because
thing.
not many government orders were in effect at
You
that
weren't
point. Is
really,
that
yeah,
right?
there's not a lot of restrictions in that quarter. And so if you filed for it, it could draw attention to your claim. We've advised for many clients to withdraw some of their Q3 2021 claims, not files that not returns we filed, but people come to us for a second opinion. We're like, okay, we agree with the up to here as far as eligibility, but this part you should withdraw these claims because you don't have a basis for eligibility. There's also some issues with some preparers with the amount of employees and kind of playing games in that way. The 2020 credit, if you had more than 100 full-time employees in 2019, the only qualified wages you received, which is how the credit's calculated, was whether or not you paid somebody not to work. And then in 2021, it went up to 500. But we've seen people with 30,000 employees file, 15,000 employees file. And so the question really there is, did you pay people not to work? PTO does not count. Vacation time does not count. COVID bonus pay does not count. So what happens here? What you need to be looking at is to make sure that you paid somebody to not provide services, to stay home. That's the point of the credit. And really the reason why Congress is targeting small employers is because they have less ability to kind of move with the trends and what's going on in the marketplace, whereas a large employer can kind of weather those storms a little bit easier. So to give them a credit for when you paid somebody not to work, that's one thing, or health insurance while they're on unemployment, something along those lines. But to pay for PTO when somebody's going on vacation, it's not the same thing. And it's certainly not how the IRS would deem a qualified wage.
Okay. Okay. So no, that's clear. Definitely important things to look out for. Have you ever been asked to provide an opinion to a criminal defense attorney before?
I have not been
And
asked to provide an opinion for a criminal defense attorney. We have done some expert testimony just in general on the civil side, though.
okay, what kind of expert testimony?
Somebody had gotten fired from their position and hadn't received the refunds in time, or the employer argued that because he didn't receive the refunds in a certain amount of time, that the employee was at fault and wasn't entitled to a loan payback of about $250,000. And so it was about providing truly how complicated the credit is, whether or not that was appropriate for that individual in their job, and whether or not they should have employed somebody a lot earlier to receive the credit.
How does a how does your your typical client, and let's see if we can, see on the ERC side, how do they usually come to you? Is it usually their accountant saying you should probably speak to an attorney, or is it more so them Googling? What are you finding as far as in your client base and leads and on the ERC side of things?
We've seen it as both. We get referrals from attorneys, we get referrals from accountants. Some businesses are starting to break up and they need to understand what happened to the credit they filed for a year and a half ago. Partner A is leaving, partner B wants to take the business into a different direction. What do you do with these credits? How do you draft around it? How do you make sure everyone's protected? Maybe you should get a second look, make sure it's accurate and that you don't need to do anything additional in order to receive your funds. Sometimes we get folks through like presentations and things like that we give, just like continuing education, but that's usually through like an accountant or attorney referral.
Yeah. Okay. So what do you see? I mean, what are the next few months, the next year kind of look like here? Are you anticipating a lot of, I'm certainly anticipating a significant increase in criminal. I think that we're at least in South Florida, the DOJ still has their hands full with the healthcare side of things. PPP is kind of weeding out a bit. We're not seeing the kind of rush regarding that from the Department of Justice criminal side. Now they're really focused on, still, and again, South Florida, which is the hub of all things healthcare, COVID testing kits, and they're still dealing with all that. Not, I wouldn't say like an explosion of ERC, but we certainly believe that it's one of the next major things.
Yeah, absolutely.
That's coming, right?
Yeah, absolutely. I think you're going to see a big uptick, at least in investigations. So maybe not in full-on prosecutions, but I would imagine people will get you involved early when there's like CI investigation, CI showing up at their house, asking for records, asking for documents, putting forth an investigation. We believe that the IRS is going to ramp up the examination process. There's two types of exams. There's a correspondence audit and then a revenue agent, where revenue agent comes in and asks for a bunch of documents. They issue an information document request. You have to return it. You go back and forth a bunch. It can take a long time. I think there's going to be a fair amount of those, but I think there's also going to be a lot of just correspondence audits, like sending a letter, hey, we're not sure if you're eligible. You should send this stuff back. Let us know as soon as possible. Otherwise, we're going to disallow your claim in 30 days. Like, I think those letters are going to start kind of popping out to see whether or not people even respond.
I kind of just probe the waters of.
Yeah, see even where you're at, because I can't imagine everyone responding to that type of inquiry and then say 50% respond. You've gotten 880,000 down to 440,000, which is still a huge number, but it's more manageable, certainly. And then, how you go from there in trying to collect. But it will matter also, it's an election year. So what happens with this tax bill? And at some point in 2025, there's going to have to be a tax bill. So whether ERC is part of it, whether or not it looks similar to the bill that's already passed the House, or whether or not it gets changed up, we'll have to see.
Yeah, absolutely. How, if at all, at what point would David, if I have a client coming in, I see some red flags there, and then wanting to reach out to a tax expert, like when would be the time to contact a Rebecca?
When you're trying to determine eligibility. So if you have a fake company with fake employees, you don't need me. You could call me, I help you, but I can't add a lot of value. But if there is some merit to a claim somewhere, you're going to want a tax attorney to do that evaluation for you to make sure that they're putting out a proper analysis to determine whether or not the company is eligible, whether or not the calculations are correct, and that type of thing. What statements were made to folks as far as the credit. If somebody said every business is eligible or all businesses are eligible or something along those lines, obviously that's like a huge problem on behalf of the promoter.
So I guess, is it fair to say that if in the criminal defense lawyer's mind there may have been certain attempts at compliance um, or maybe an avenue um, where where they could clean things up, or there can be a review and audit of their own records from a tax attorney and working with us to be able to explain possibly to a prosecutor who has sent a target letter or is looking for more information. But we can kind of go through and do an audit of it and say, hey, actually, look, there might have been some confusion, but it wasn't every quarter. It was a few, and when the guidelines changed around that time, there were some differences. So do you feel that there is some room for even people right now like to get out of this, even if the government kind of has their eyes on them?
I think it depends. I think the government's going to have their eyes on them, but like there's also, if you're a little player and there are bigger players that have kind of like, you can always work in those ways and help out. It just depends on how bad the facts are, I guess. If the facts are truly terrible, I don't think there's any amount of tax attorney that I can help with. But if there's an actual claim and there's an actual business with actual employees, then it's worth getting a tax attorney involved to see if you can get any semblance of the credit. Because if so, then at least you get out of criminal world and you get into a civil problem, which is clearly much better.
Yeah, and I think that's a great point, because given that it's early and something that when we, as in the criminal world, see what's coming on the horizon, we always want to only at this kind of point. It might be maybe even too far along now, but there is a small window where the Department of Justice on the criminal side is willing to accept civil settlements. Before things get too flashy and too many indictments. And if the number is still accurate, where there's been about 450 criminal complaints and 36 indictments, we might still be in that realm, but we might also be past it. I guess it really just depends on the case. I mean, I just find it seems much more blatant and less subtle than a lot of other things that I see in kind of complex white collar defense. A lot just more obvious. This one here with the 2.9 billion. I mean, these guys are just creating fake companies and I don't know. I mean, they created around 1,300 fake companies and just fake filings, and it's kind of surprising to me that they're able to be so brazen, even though there wasn't a lot of oversight in the beginning.
No, I mean, and those guys got paid out, I think, $1 million. I'm pretty sure.
Right.
It's just the rest of it. That's still like a pretty
how does
big
that?
number.
Yeah, like so. I mean, from your perspective, as a tax attorney, 2.9 billion submitted, 1 million paid back. Like, how does that happen? Like, how does the IRS say, like, we're even going to like pay 1 million? Like, we got someone requesting 2.9 billion. How do we not stop it right there?
So when you said there was 1,300 businesses, that's your answer, because no one's looking at this as one. Unlike PPP, you're looking at these individually. And again, there's nothing on the form that links other businesses together. There's nothing that says, are you part of an aggregate group? Are you part of an affiliated service group? In which case you could enter, you'd have to like explain all of the businesses you are with. So that makes it a really big difference for the IRS. They have to figure out, okay, well, all of these claims are small. They're all 80 grand, all 120 grand. There's just a ton of them, and each return stands on its own. So how do you link them all together? So it's impressive, frankly, that they figured it out. My guess is they did the same thing over and over again. They were able to kind of link them all together.
Right. So the amount that must have been, I mean, when they get 2.9 billion of submissions to them, I mean, and then they're expending, I mean, how much time going through and weeding it down to 1.3 million. I mean, I'm not too
I think
familiar
most
with.
likely those were actually just processed, and then they were like, "Whoa," and just stopped it all. Is my guess.
That makes sense. Okay, so maybe they just like off the bat were like they sent out a few, and then we're like, okay, yeah, this
Whoa,
is
yeah, that's what I think happened. And they're trying to stop that from happening, which is why they're just not processing right now. They feel very stuck. The IRS
right.
does. It's
Yeah,
tough.
and even in less complex tax cases, what we see quite often is that at least on the criminal investigative division of the IRS is they become overwhelmed pretty easily. And often, I don't, and they do often need help from FBI and others. And here, I'm sure they're going to need to. It's just not, it's not really their kind of game. And this is going to be a big one for them because of PPP, of course, where there was some IRS involvement, but really it was all FBI for the most part. But yeah, it's just very rarely do you see. We see in healthcare cases, 300 million billed to Medicare and 150 paid out, and you're like, okay, so about half makes sense. But when you see 2.9 billion and then 1.3, but that makes a lot of sense that they probably were like, yeah, we're just going to cut this off now. It was pretty blatant, but.
Yeah, the fake businesses you think would be easier to spat. And that's like the difference, I guess, between like the civil and the criminal. You're going to have a lot of people who have very aggressive positions, people who took things all the way through, like I said, September 30th, 2021, that are in civil land. But criminal land is really going to be made up businesses, made up employees, and then trying to get these checks.
The qualifications, another thing too that I've seen, which is interesting to me. I'd like to hear your opinion. The qualifications for the ERC, just the guidelines and the rules and how you qualify, who's eligible versus PPP or EIDL, in my opinion at least, are significantly more nuanced and complex than PPP. You have a certain number of employees, and you have a certain payroll, and it occurred during this time, and so I guess it's, let's say, shocking, but it seems that maybe the preparers either just disregarded it entirely, or are we seeing more sophisticated work on the preparer's side here? Because in order for these claims to be to even pass the just basic checks going in, or
I don't think they're sophisticated. Maybe. But I
PPP
think,
is easy, right? Like anyone could do it and make up a couple things here, quarters, and then amount of gross revenue lost, and whether there's an order in place, and they're just making it up on these forms.
yeah, the employee retention credit. So it's just on a 941X. So it's just like wages reported, the portion of non-refundable credit, refundable credit, and then the totals. It's not, you're not actually claiming any eligibility on there. That's the part of the problem, is that the IRS really, in the beginning, if they had fixed the forms a little bit, it would have made it easier for them to process, because you don't actually know what somebody is claiming their eligibility is, or how many full-time employees they had in 2019. There's no basic information on that form that creates any information regarding eligibility or the calculation of the credit.
Gotcha. Really interesting. So, what's your number one piece of advice that I should be giving my clients if they come to me, and if they're not the one who's doing the 2.9 billion, but they come in and they say, I think I met a promoter, I saw this advertisement on the radio or on Instagram or social media that I could get X, Y, and Z, and I went for it. Now I think the feds are going to come knocking. what's your best advice to that individual?
I would withdraw those claims.
Okay.
My understanding, and I don't know if that necessarily is going to completely protect you, but my understanding is that once you've withdrawn the claims, it's as if you never made the claim in the first place. Doesn't necessarily protect you from criminal charges, but there's so much out there. If you take your claims out, I think it greatly reduces your risk in those cases. Now, if you've already gotten paid, that's where it gets tricky. And you'd want to do either one of those voluntary disclosure programs, or, you know, certainly have a conversation with you about whether it makes sense to pay the money back, or, you know, what's the best way to proceed, how to get.
Or just hire Rebecca.
Or hire Rebecca, hire David.
Yeah.
Figure it out and see what's the best way to go.
Yeah. Well, I mean, this is really, really, really interesting. And I think that we are, you know, even though some of these, at least on the criminal side, have been brought, you know, a year ago, that we haven't even really scratched the surface, right? Because it's with the moratorium, and now they're just starting to get through these and have probably billions and billions worth of dollars more to get through. As far as these claims, it's going to be very interesting to see where we go. And certainly on your side, maybe for me, it's, you know, I don't want to say easier, but certainly we need the help of the tax expert attorneys like yourself. So.
No, absolutely. I think you're going to start to see an uptick on these investigations, and how they can get from like little promoter to, you know, the bigger people who were, you know, directing those guys. I think some people really probably did think that every business was eligible and this is a COVID program and that you should do this. But the more sophisticated players behind the scenes knew what the rules were, and should have been playing by them, frankly.
Yeah. Now, really, one more question that's crossed my mind. The letters that the IRS is sending, what are these letters or these notifications? Are they sending notifications to individuals that they may have received money improperly? And are there instructions on that form? Has that part started yet?
So right now, the IRS is in a position where I think 98% of the audits are going to be in claims that have not been filed, like returns that have not been processed yet, refunds that have not been paid out, because of the way the statutes work. So people who have gotten their money are probably okay for now, unless those that new legislation passes. The IRS was really hopeful that tax bill was going to pass. They're going to get more time on the audit statute, because then you can kind of claw back some of the money that you've already left out, versus you have 1.4 million returns, 880 pre-moratorium, and then, you know, the bulk of that, the rest of it after the moratorium was passed. So you're 1.4 million returns in the hole, and you've got to start making some progress with them, because businesses are really having some trouble.
Okay. There's those three categories, right? And it's or those tranches, or those three silos, and it's high
the
risk.
disallowance letters are going to be just disallowing your refund. They won't have already gotten paid. It'll be like a preemptive.
Right. So we're not expecting that we're going to get. I mean, like in our world, much more like, I guess, I mean, a target letter be coming from someone from the DOJ, a prosecutor, or an agent. But as far as from the IRS, are you anticipating that once they get through this massive kind of backlog, that and they identify more, that they are going to be putting more people on notice and trying to claw back, or that's going to be potentially way down the road?
I think it's going to depend on the legislation, because the audit statute closes for 2 quarters of 2021 in April, and that's only, you know, we're like 9 months away. It takes the IRS quite a long time to audit a case, and you need to be able to have time to get it through and get your manager approval and all that kind of stuff. Like right now, for an income tax audit, they wouldn't pick up 2021 as a tax year. You'd be in 2022, just because you need to have a certain amount of time. And so for people that have already been paid in that spirit, it seems highly unlikely to me. But if legislation passes and they get 6 years, you'd be looking at some clawbacks.
Okay. All right. Well, certainly a lot of work for both of us ahead, which is exciting stuff.
Absolutely.
But yeah, I really appreciate you taking the time to speak
Thank you
with me
so
on
much.
it.
I appreciate it.
Yeah.
Thanks,
All right.
David. Take care.
Bye.
Bye.